Ready to let the people in the waiting room?
Let's let them in.
You can let them in, Josh. You want me to?
I got it.
Okay.
I believe we are now live. Yes, we are. Good evening, everyone. My name is Hamza Khan, and I'm one of the co-chairs of Progressive Maryland's Housing and Judiciary Reform Task Force. This task force was formed because of the urgent need here in Maryland to see reforms both in our court system on the criminal and civil sides, and also to address the ongoing challenges through our court system dealing with housing issues. We have seen a lot of activism recently around the issue of evictions and rent procedures in terms of collecting rent and protecting renters in the state of Maryland. However, we haven't seen as much being discussed around the issue of foreclosures. There are several reasons for this. One reason is that we have to accept that we have built a culture of shame that comes with being in debt to anyone. And as a result, many homeowners are afraid of talking about the challenges that they have going on in their lives and in their financial lives rather. And so the important work that we have to consider today is that as many as 1 in 10 Marylanders are currently facing foreclosure in our state. And Maryland has been one of the capitals of foreclosure in our country, going back for almost a decade or longer, back to the Great Recession. We can't allow this to continue. At this point in time, after watching 1/3 of our economy be wiped away by a global pandemic, countless small business owners, hardworking Marylanders, and non-deadbeats are facing foreclosure every single day. And the work we have in front of us is that we want to work to ensure that no one loses their home during a global pandemic, and that afterwards we work together as a state to make sure that everyone who wants to remain in their home can do so while working to pay off their debt. And that's incredibly important to hit here. Nobody wants a home for free. Everybody wants to pay off their debt and work together for a better economic future for all Marylanders. And with that, we've pulled together this amazing panel tonight to talk about the foreclosure crisis as we see it happening here in Maryland, and the fact that we are looking at a tsunami of foreclosures down the pipeline as soon as states of emergency are lifted across the country. With that, I'm going to hand this over to one of my co-chairs, my amazing partner in crime, Liz Johnson from the Prince George's County NAACP. She has been an amazing advocate for many years on the issue of foreclosures and on protecting homeowners, and she runs a nonprofit known as Strategic Housing Solutions. With that, Liz, I hand you the floor.
Thank you so much. Well, as Hamza said, my name is Liz Johnson. I'm a member of Progressive Maryland's Housing and Judicial Reform Task Force as well. And in addition to being the Executive Director of Strategic Housing Solutions, I am a member of the chairperson for the Prince George's County branch of the NAACP's Housing Committee. And thanks for being with us tonight. So we have a very robust program. So without further ado, I'm going to introduce you to our panel of experts that's going to be with you. In alphabetical order, we have attorney Raouf Abdullah. He is the principal attorney at his law firm in Upper Marlboro, Maryland, a graduate of Columbia University and Suffolk University Law School in Boston. He has extensive trial experience working as a trial attorney with the Corporation Counsel for the District of Columbia, and is an assistant state's attorney in Maryland, trying cases both before Maryland's district and circuit courts. We have attorney Sheila Durant. She's been practicing law for more than 41 years. Hard to believe. Looks so great. And she does mediation for more than 10. She's served as the assistant city solicitor for multiple mayors in Baltimore and 16 years as senior counsel to the Housing Authority of Baltimore City. She concentrates on civil matters, including bankruptcy and foreclosures. There's a very interesting highlight about Sheila. She was the first African-American woman to represent the National Football League Professional Association for over 3 years. Then we have Beth Jacobson. And Beth Jacobson is an extraordinary paralegal who has been working with Strategic Housing Solutions. She's been an expert witness for over 10 years. She provides attorneys with all kinds of motions and various kinds of services that has to do with fighting foreclosure. We have attorney Thomas Ruffin. He's president of the International Association of Black Attorneys and barred in Maryland and the District of Columbia. He's a guy that's really not afraid to speak truth to power. He's a fierce fighter for justice in many realms, including fighting for America's Black farmers, fighting against mass incarceration, and now ready to join the fight against the illegal stealing of homes through foreclosure. We have attorney Peter Silva. Attorney Silva is a zealous advocate for consumers, workers, and individuals whose rights have been violated by government, employers, and financial institutions. Over the past decade, attorney Silva worked on behalf of Maryland, DC, and Virginia homeowners and has prevented dozens of foreclosures and obtained millions of dollars in damages for his clients. He's a member of the National Association of Consumer Advocates, admitted to practice in the courts of Maryland, Virginia, and the District of Columbia, the United States District Court for Maryland, the District of Columbia, and the Eastern District of Virginia. He's also admitted to practice before the United States Court of Appeals for the Fourth Circuit and the District of Columbia. Now, we're going to be joined, as Peter, as Hamza mentioned, we're going to be joined by Senator Jill Carter, who's going to talk about the foreclosure legislation she sponsored in the Maryland Senate, along with Delegate Vaughn Stewart, and he's with the House of Delegates. She's going to be dashing to our Zoom from a committee meeting, and we'll just have a couple of minutes to talk. However, I wanted to share a little bit about Senator Carter, who's billed as the People's Champion. She represents Maryland's 41st Legislative District, Baltimore City, in the Maryland Senate. She previously represented the same district in the Maryland House of Delegates. She's earned a reputation as a fiercely independent champion for justice and as an unyielding voice for the voiceless and underserved. So she'll be with us a little bit later on, but I just wanted to let you know a little bit about her, because chances are we won't have time to talk about her background when she gets here. So without further ado, we're going to turn our show over to Beth Jacobson, who's going to be our very first person to talk to you about our theme, which is foreclosures. What you don't know can hurt you. And Beth is going to be telling you all about the various things that can hurt you as you move forward with a foreclosure challenge. Beth, what you got for us?
Thank you very much, Liz. Good evening, everyone, and welcome. As Liz said, my name is Beth Jacobson. I'm a member of the NAACP as well as the nonprofit Strategic Housing Solutions. I have been working and advocating for homeowners facing foreclosure since 2009. I have been admitted as an expert witness in this field nationally. I received a U.S. congressional recognition in 2009 for providing assistance to Maryland homeowners facing wrongful foreclosure. I blew the whistle on my former employer, Wells Fargo, due to its reverse redlining and predatory lending practices, which resulted in a $175 million settlement with the Department of Justice. As a state, we are still recovering from the aftermath of the Great Recession. Prior to the COVID-19 pandemic, Maryland was number 3 in the country for foreclosures. We are about to face another foreclosure crisis that may result in even a greater loss of homes. The foreclosure crisis of the Great Recession was primarily due to the sale of predatory subprime loans and reverse redlining. These loans accounted for roughly 22% of the loans originated between 2004 and 2008. However, over 63% of these loans were foreclosed upon. African American and Latino borrowers are 30% more likely to receive the highest cost subprime loans relative to white subprime borrowers with similar risk profiles. What we are facing now is mortgage delinquency due to mass unemployment as a direct result of COVID-19. The current rate of mortgage default in Maryland is 9%. That is just about 1 in every 10 households potentially facing foreclosure. The Consumer Financial Protection Bureau issued a report last week stating that in 2020, borrowers who have fallen behind at least by 3 months on their mortgage has increased over 250% and is now at a level not seen since the height of the Great Recession. In fact, delinquencies on FHA loans have now exceeded those as seen in the Great Recession. To be an informed homeowner, you need to know the language used by the mortgage industry. I'm going to define some of those terms, and a complete list of definitions will be available to all attendees of this call. The lender, that is the entity that originated or processed the loan and funded the money for the loan. The lender's name appears on your documents, such as the note and the deed of trust. The deed of trust is the contract or the document that lays out the terms for borrowing the money. The note is the IOU. It is the document that sets out the interest rate and the term of the loan. The servicer is the entity that issues to you your monthly mortgage statements, pays your taxes and insurance. It is the entity that you make your monthly mortgage payment to. In most cases, the servicer does not own your loan. The owner or investor of your loan is the entity that owns your loan. In most cases, the lender sells your loan to a third party who is then the investor of your loan. It is extremely important to know who is the investor of your loan. For example, under the CARES Act, only federally backed loans are protected. Those loans include the investors Fannie Mae and Freddie Mac, as well as FHA and VA insured loans. Forbearance. This is an agreement offered by the servicer on behalf of the owner or investor. This will suspend your monthly mortgage payments, but this does not forgive the payments. The borrower must discuss with the servicer what will happen at the end of the term of the forbearance, as it's the investor that determines what happens next. Peter Silva will discuss forbearance via the CARES Act. Dual tracking is where the servicer puts the borrower literally on 2 different tracks at the same time, the track towards modifying the loan and the track of foreclosure. If the servicer can reach the end of the track with the foreclosure first, the borrower loses. The borrower literally loses their home. The way that the law is currently written, a borrower only has a full protection from dual tracking if it's their first application for a modification after becoming delinquent on their loan. A predatory loan is where the lender has failed to account the ability of the borrower to repay the loan. That sounds like a stupid move on behalf of the lender to sell a loan to a borrower who doesn't have the ability to repay a loan. However, the lender pre-sold the loan to investors prior to the borrower even closing on the loan. The lender has no skin in the game. It wasn't until after the Great Recession that Congress actually passed a law stating that the lender had to take into consideration the borrower's ability to repay the loan. Why would a lender sell a predatory loan even if they knew they were setting up the borrower to fail? Because the lender made 3 to 5 times, even 10 times more money selling a predatory subprime loan rather than a conventional prime loan. The lenders, the banks, and Wall Street made money selling predatory loans. They made money betting on the fact that the borrowers would default on the loan and made more money keeping borrowers in foreclosure limbo until they ultimately foreclosed on the borrower. Reverse redlining is where the lender or the mortgage company target mostly the African-American community to sell specifically predatory loans. In Maryland, particularly Baltimore City and Prince George's County, these lenders would target the churches to invite their parishioners to attend a seminar where the mortgage company would donate to the church $350 for every refinance or purchase loan that was sold. What the ministers and the parishioners did not know was that the loan officers were selling only predatory and subprime loans. African American and Latino borrowers are over 70% more likely to be foreclosed upon than white borrowers. The USDA, which is the US Department of Agriculture, was more than 6 times as likely to foreclose on a Black farmer as it was to foreclose on a white farmer. The current rate of homeownership of African Americans is now at the same level it was in 1968 when the Fair Housing Act was enacted. Black homeowners are 3 times more likely than white homeowners to be behind on their mortgage payments as of December 2020. As we are facing another foreclosure crisis due to the pandemic, we need to look at the fact that African Americans are experiencing more serious illness and death due to COVID-19. In fact, Black people are 4 times more likely to die from COVID-19 than white people. We will again be facing a housing crisis that will disproportionately affect Black and brown people. The current protections via the CARES Act protect only those with federally backed loans, which represent only 50% of the total loans. Governor Hogan did issue an executive order on December the 17th that requires servicers of non-federally backed loans to allow borrowers the opportunity to request a forbearance. However, at this point, there is no enforcement of the requirement. Servicers are failing to comply with Governor Hogan's order with no penalty and no recourse. When the foreclosure process starts back up on April 1st, the servicers will have to file a document stating that it did offer the borrower an opportunity for a forbearance. However, if Governor Hogan rescinds this order at the same time he lifts the state of emergency, there will be no protections for borrowers that do not have federally backed loans. Again, 50% of the borrowers will have no protections. Let me be clear that while the filing of foreclosure actions has been stopped since last April, since this past July, there have been foreclosure sales every day in every county in Maryland. Foreclosure sales have been occurring in the middle of a state of emergency and a worldwide pandemic. The first step of the foreclosure process in Maryland is the issue of the notice of intent to foreclose to the borrower when the borrower fails to make their payment on time. The process has been suspended since last April and is set to start up again next month, April 1st. The actual foreclosure complaint or the order to docket is filed in the circuit court in the county where the borrower's house is, and it is typically 120 days or 4 months after the first missed mortgage payment. A final loss mitigation affidavit will be filed and issued to the borrower when the servicer claims that it has exhausted all loss mitigation options, which is generally 45 days after filing of the order to docket. This document is extremely important as it allows the borrower to request mediation. Generally, mediation is only for those properties considered owner-occupied as opposed to investment properties. The mediation process requires the borrower to submit an application for loss mitigation specifically for a loan modification. It also requires the servicer to provide the borrower several documents, including a transaction history and a detailed reason why the borrower was denied a loan modification. I've attended well over 100 mediations in the state of Maryland, and not once has the servicer complied with submitting these required documents. Neither the Office of Administrative Hearings that oversees the mediation process nor the judges at the circuit court will enforce the requirement that the servicer and their attorneys must provide the borrower with these documents, nor will they dismiss the foreclosure action as allowed by law for non-compliance of the mediation requirements. Once mediation is held, the borrower only has 15 days to file a motion pursuant to Maryland Rule 14-11 to request a stay or dismissal of the foreclosure action. Untimely filing of this motion may result in the borrower waiving any potential defenses they may have. If the property is not owner occupied, then the borrower must file this motion within 15 days after the order to docket is served. When the borrower walks out of mediation, the foreclosure attorney is quick to state that there will be no sale of the borrower's home while the servicer is reviewing the application for the modification. However, no one, not the administrative law judge nor the foreclosure attorney, tells the borrower they only have 15 days to file a motion laying out their defenses to a foreclosure. The sad reality is that most judges are predisposed to think that the borrower is a deadbeat, that it's failed to pay their mortgage, and that's exactly what the attorney from the bank will state. The first thing out of the attorney's mouth is that the homeowner hasn't made a mortgage payment in X amount of days. A foreclosure action is called an in rem proceeding or a court of equity. Recent case law is clear that a party attempting to foreclose on a borrower must have clean hands. The theory of unclean hands means that a party attempting to foreclose cannot, for example, use forged documents, or they cannot be untruthful in an affidavit contained in the order to docket. A borrower can provide documentation that the loan that they were sold was a predatory loan, that the lender failed to take into account the borrower's ability to repay the loan, meaning that the foreclosing party has unclean hands. This is something that I've testified to as an expert for borrowers across the country. The judges need to be educated. In the past, borrowers may not have been able to find a competent attorney to represent them in a foreclosure action. Many attorneys only offering the filing of a bankruptcy to stop a foreclosure. The filing of a bankruptcy may be the only option to stop a sale, but the borrower must plead their defenses in the bankruptcy proceeding, or the automatic stay will be lifted and the borrower will be back in circuit court facing a foreclosure sale. At Strategic Housing Solutions, we have assembled a team of attorneys who know how to defend homeowners against foreclosures, as well as review the documents for non-compliance by the servicer, the investor, and the foreclosure attorneys to various state and federal laws. The key for the homeowner is to reach out to us as soon as you're having issues making your mortgage payments. The sooner we can get involved to assist the borrower, the better the outcome. We can assist those borrowers who've not yet received the notice of intent to foreclose, as well as those borrowers currently in foreclosure. And we may be able to provide options even to those borrowers who've lost their homes in the past 3 years. Thank you, Liz. I'll turn it back over to you.
Thank you so much. But guess what? We have a surprise visitor. And Hamza is going to introduce him. Hamza, are you there?
I'm right here. Can you see me and hear me?
I can see and hear you.
All right. Well, thank you so much for handing it over to me. Liz and Beth, thank you for that very informative talk. I'm going to invite up Delegate Vaughn Stewart of District 19 in Montgomery County, Maryland. The delegate has sponsored a bill to help us deal with the current crisis around foreclosures, and I will let him speak about the bill starting right now. Delegate Stewart, you have the floor.
Great. Well, good evening, everyone. Thank you very much, Hamza. I appreciate it. It's been a pleasure to work with Hamza and with Beth and with Scott and with so many of you on this piece of legislation that Hamza mentioned. Just first, by way of introduction, my name is Vaughn Stewart. I represent kind of the middle part of Montgomery County. It's District 19, and I serve on the House Environment and Transportation Committee, which also includes housing issues. And it's been my pleasure to work with this this amazing coalition of advocates around this bill, trying to basically make our foreclosure process during this pandemic a little bit more just and a little bit more humane. And it's been also a pleasure working. I know that she has at least a staffer on the call, but it's been a pleasure working with Senator Jill Carter of Baltimore City on this bill. She's the Senate sponsor. And so this is House Bill 1009, and then in the Senate, it's Senate Bill 724. And I'd love just to take a couple of minutes to walk through what's in the bill and then kind of give you a little bit of a call to action about what the status of the bill is and how I hope that y'all may be able to help us out a little bit. So I don't need to tell y'all, obviously, that this has been a really harrowing time for homeowners across the state. There was pre-existing housing insecurity in Maryland. We were already a foreclosure capital, and the pandemic has just exacerbated that problem. And we've got at least 20%, 25% of homeowners who are struggling to afford their mortgage payments and who are worrying that they're going to be facing an imminent foreclosure problem. And so what the bill does is basically a bunch of common sense provisions to try to keep people in their homes. So for example, it codifies the existing foreclosure moratorium, both on the state level for non-federally backed loans and on the federal level for federally backed loans. And it extends that through the duration of the state of emergency. Because to me, the idea that anyone would be foreclosed on during a literal state of emergency, no matter how quickly the vaccine comes or whatever, we're going to be feeling the economic aftermath of the virus for months and years to come. The bill also provides guaranteed forbearance rights, which are going to be set to expire on both the federal and state level very soon. Forbearance is really the only thing that has kept thousands of Maryland homeowners, hundreds of thousands of Maryland homeowners in their homes throughout this pandemic, is because they had access to those forbearance rights. We've got to make sure that those are universal and they're extended also through the state of emergency. Another big problem we're having is just notice of these rights. I mean, that's why I think this event is so amazing, and I'm so glad to be a very small part of it. A lot of folks are not aware about what rights they have under either federal or state law. And even more pernicious than that, a lot of servicers, a lot of banks don't understand the laws that currently apply to them. There are a number of surveys that have gone out where law firms have asked the banks, what are you doing to comply with, for example, the Governor Hogan's executive order? And 2/3 of them back in January said, we're still thinking about it. We're still considering it. We'll figure it out eventually, which basically means that only a third of servicers at most are actually complying with the law. And so we got to notify them. And so what the bill will require is for servicers to mail notices to all borrowers, all homeowners, with all their rights under federal and state law as a way to notify both parties of the rights that homeowners have to remain in their homes. I think maybe the most crucial part of the bill is that it puts guardrails over the post-forbearance repayment process. Now that's a mouthful, but what it basically means is that a lot of folks are going to be exiting forbearance this spring. Some folks are already exiting forbearance because, as everyone remembers, everyone's been kind of thinking back how it was exactly 12 months ago, exactly 1 year ago, since a lot of us sort of started first becoming aware of how serious this pandemic was. In fact, yesterday was the 12-month anniversary of the House and the Senate of Maryland, the Maryland General Assembly, announcing that it would have a shortened session, that it would be adjourning early for the first time since the Civil War. So it's been 12 months since a lot of this stuff went down. And that's how long these forbearances last. You can get a forbearance right, you can push your payments back, but only for 12 months. And so a lot of homeowners are going to be coming out of that protection in March, in April, in May. And then what happens next? We've already heard a lot of reports that banks and servicers are sending homeowners balloon payment demands. They're basically saying, oh, you haven't paid us for 6 months because you were on forbearance. All right, well, you got to pay up and give me 6 months of mortgage payments right now, or you're out, and we're kicking you out onto the street. And that, to me, is, it's inhumane, it's immoral, it's deplorable, and so we've got to stop that. And so what the bill does is that it prevents balloon payments, and it sets as a default option that the repayment plan will be tacking any arrears, any mortgage payments that are due, tacking those to the end of the loan. So if you've got a 30-year mortgage loan, you've paid, say, 10 years of it off, then at the end of that 20 years, you can worry about paying this money back that you couldn't pay during the pandemic. And hopefully 20 years from now, you will have righted your economic ship enough where that extra payment won't feel like very much at all. And then lastly, it's about accountability in the bill. There's a private right of action that allows homeowners to sue if their servicer violated the law. And we also want to add to the bills an attorney general enforcement regime, just to make sure, because as I mentioned, we know that a lot of servicers are not complying with the law, and we want to make sure that there's some tough rules in place that either homeowners or the attorney general can go after them for violating the law. And then lastly, I just want to give an update on what's going on with the bill. So we had a hearing a couple weeks ago. Beth was there, Scott was there. It was a good hearing, but it became very clear to all of us that the servicers and struggling homeowners who can't afford their mortgage payments are living in completely different universes. To hear the bankers talk about this bill, you would think that this was the greatest economy that we've ever had, that no one is struggling. It's all sunshine and rainbows. It's just a complete alternate reality that they tried to convince the committee of. And to be honest, I think that they were pretty effective. The bill has been sitting in the House Economic Matters Committee since the hearing. It has not moved. It has not had a vote. And the deadline is Monday. So today is Tuesday. We have 6 days left to get the bill out of the committee and onto the House floor before what's called in Annapolis crossover day, which is the deadline that House bills have to pass the House before they go over to the Senate. So we've got until Monday. We got 6 days left. And so that's where I hope y'all can come in and help us out. And I'm sure that Hamza and Scott and Beth are happy to send additional contact information out for members of the committee, but we really need y'all to email members of the committee and tell them to move this legislation out as quickly as possible. Now, they may want to put amendments on. Who knows what kind of weakening amendments they might put on. I expect there probably will be a few attempts to gut the bill in a variety of ways, but we need at least something out, and we need it very soon, or there are going to be a lot of Maryland homeowners who are going to be kicked out onto the streets. And so I hope that you'll stand with us if you're at all moved by anything you hear tonight, and email the legislators on the House Economic Matters Committee, even if they're not your legislators. Bombard them with emails. I think that your voice will be heard, and we could really, really use your help. So again, it's a pleasure to spend a few minutes this evening with everyone. I really appreciate all your interest in this work, all of your passion. It's only through organized people that I think we can overcome organized money, which in this case is seen in the bankers lobby, which is an extremely powerful force in Annapolis. So we need to all band together to make sure that our collective voice is more powerful and is heard. So thanks very much.
Thank you very much, Delegate Stewart, for joining us and filling us in on what's been going on in Annapolis. You heard it yourself directly from an elected official, folks. We have 6 days to get this bill out of committee in Annapolis. The banking lobby has put everything they can to pull the wool over the eyes of elected officials in order to make sure that they can recoup whatever claimed losses that are non-existent and sell people's homes for a pretty buck. To give you an idea, over the course of a home loan, a bank will make anywhere from 3 to 5 to 10 times as much money as was originally lent out. That is a serious problem. And so they have an interest either way in either seizing someone's home and selling it, oftentimes by skirting the law, or by creating their own laws, which is what we've seen happen for the last couple of years, or last couple of decades here in the US. Now, coming back to the bill at hand, I'm going to invite up Daniel Zancatin from the office of Senator Jill Carter. Senator Carter sends her apologies. She's currently defending her bills on the floor of the Senate, and therefore it's important for her to be working for all of us out there. And so she sent her legislative director, Daniel, to join us. Daniel, are you here with us right now? He was a second ago. Did we lose you?
Yes, here I am. I'm sorry. I was muted. I was waiting for you to unmute. Yeah. Hi. Thank you. I'm really glad to be here, and I know Senator Carter is very bummed. I just texted her a few minutes ago. Very bummed that she can't be here herself. She's in the midst of voting session in judicial proceedings in the Senate, and there's an awful lot going on. And candidly, I came in on the tail end of Beth, and I heard Delegate Stewart talk. I don't have an awful lot to add. I mean, Beth nailed it, and Delegate Stewart, of course, just kept going with it. So this bill is important. Mortgage problem right now is a ticking time bomb, and it's going to go off. The question is, how badly are people going to get hurt when the state of emergency is lifted, when the moratorium is lifted? We need this, and in the Senate, it's Bill 724. We need this bill to put the appropriate guardrails on the mortgage lenders so that once the moratorium is lifted, there is some way for people actually to pay back what they're in forbearance on. The balloon payments are going to cause an awful lot of problem. So I will take video off. Thank you. I appreciate that. Okay. The moratorium, once that's lifted, people are going to end up on the street unless there is legislation in place to guide what the lenders can and can't do. People have referred to the pandemic as a war. All wars need a Marshall Plan when they're over. And this bill is exactly that. And I think it's enormously important. As I say, Delegate Stewart and Beth Jacobson have laid out all the detail, I think, of the bill necessary. And we just want to have everybody contact the committee chairs and committee members for both houses. It's in, I believe, the Finance Committee in the House of Delegates. It's in Judicial Proceedings, JPR, in the Senate. Bombard them with emails, with phone calls, with skywriting, whatever. They need to hear your voice. It's not going to happen otherwise. As Hamza said, as other people have said, the bankers lobby is powerful, they're expensive, and they have very, very big wallets and megaphones. We need to outshout them, and that's what we need to do. And that's pretty much all I have on this bit. I'm going to have to get back to staffing Senator Carter during voting session. Right now, she's working on some criminal justice reform bills right now. And despite some trouble with leadership in JPR, I think we've got some stuff that we can move on. And if you'd like to know about those bills, I'm happy to include them in the chat or send Hamza a list of them once we're done. I appreciate you guys taking the time. And as I said, Senator Carter really wishes she could be here, but she's physically stuck. She has to be in the Senate to do this.
Thank you, Zach, so much for joining us.
Sure.
And we look forward to being in touch with you very soon. Please do drop a link if you'd like of the bills that the senator is supporting. I can tell you that we are supporting all of them. And in addition to that, I just want to jump in before I hand it off the list. My father is a former mortgage executive for 25 years, and he wanted me to share tonight that what he has seen the mortgage industry do in Maryland is not only unethical and unconscionable, but it is an assault on our democratic freedoms. Think of it for a moment in these terms. If 1 in 10 people do, unfortunately, or even as many as 25% of people in Maryland who own a home, as Delegate Stewart pointed out, lose their home during the current pandemic, what does that mean democratically? That means that 1 in 4 constituents no longer are constituents in their districts and in Maryland. That offers a perverse incentive to politicians who are not supporters of Progressive Maryland's agenda, who do not care about protecting homeowners and rather simply want to perpetuate their own power. That offers them a perverse incentive to do whatever they can to make sure people do lose their homes. We are facing off against one of the most dangerous lobbies in America today. As the son of someone who was a banker for many years of his life and someone who worked in the lending industry when I came out of college for a few years, I'm telling you right now, we need to stop this and we need to get ahead of it. And with that, I hand it off to Liz Johnson.
Thanks so much. And I was really glad to hear from Vaughn and Jill's representative. So now we're going to hear from Attorney Peter Silva, who's going to also share with us some information on how what homeowners don't know and what they need to do to protect themselves. How are you, Peter?
I'm doing well. How are you?
I'm good.
Good. Thank you so much for having me here tonight. My name is Peter Silva. I'm a partner at the firm of Gowan Silva in Winograd. I practice primarily foreclosure defense and mortgage servicing violations in the District of Columbia, Maryland, and Virginia. I'm honored to speak here tonight. I want to thank Progressive of Maryland, the NAACP, Strategic Housing Solutions, and everyone else for putting on this seminar. As I often tell my clients, I'm sorry we're meeting under these circumstances. If you're talking to me, something has gone seriously wrong. That's an unfortunate way to have to meet so many people as I do. But what I also tell them is that I'm here to help, and I'm here to do the best that I can to make sure that you can get through this ordeal one way or another. Foreclosures are like snowflakes. Each one of them is different in its own way. And I was trying to come up with a topic tonight that I thought could help the most people, or the most broad section of people. And so given the fact that we were in the middle of COVID and the discussion around the bill that we're having tonight, what I wanted to focus on is the CARES Act and the protections that are out there for certain homeowners. These protections are ever changing, and I actually have updated information even from the delegates' information. So we're going to go over that. But first, I just wanted to go through a few points that I would say really help with anybody that is facing foreclosure or is in foreclosure. One is get help early. I cannot stress this enough. The earlier you get the help, the better the outcome is going to be. Things never get better by ignoring them. Let me say that again. They never get better by ignoring them. The interest accrues more. The taxes accrue more. You get further and further behind, and it gets more and more difficult to come and work out a solution that works for everybody. 2, use the rules to your advantage. There are lots of rules that the mortgage companies are supposed to follow. And if you use them correctly and you use them up front, you can use them to your advantage to leverage them to get a better outcome, whether that's a workout, a sale, a settlement, whatever that is. You should use the rules to your advantage. 3 is keep records. Keep all of your records. Keep everything they send to you. Keep a list of all the conversations that you have. Put everything you possibly can in writing. We deal with these mortgage servicers over and over again who outsource the work all throughout the country and all over the world. They pay the people on the phone, near minimum wage, and they have turnover like you wouldn't believe. And so as soon as you have a conversation with someone, you might never hear from that person again, and what they say might go along with them. So you should definitely keep records. And the last thing is be practical and be realistic. You need to know the situation you're in, and you need to make the right decisions based on the information that you have, not based on the information that you learn off the internet or that your friend's brother, sister told you. You need to look at it, and you need to talk to a professional as soon as you possibly can. Now, let's turn to the CARES Act. You might have heard it talked about several times tonight, but the CARES Act is the Corona Aid, Relief, and Economic Security Act that was passed in March of 2020. What it did for homeowners was allowed the homeowners to be put into a forbearance as long as you were you owned a property that was, as long as you owned a property that was backed by a government-backed mortgage. And what that means is if your loan is owned by Freddie Mac, Fannie Mae, if it's backed by insurance by FHA, USDA, or any other government agency, and the other one is USDA. So how do you know whether or not you have a government-backed loan? Well, if you have a Freddie or a Fannie, you can actually search online to see if you have those loans. We have provided a handout along with the materials for today, and in there you can follow those links. If you have a government insured loan, it's a little bit more difficult. The way you do that is you're going to look at your loan documents and look for indications that it's USDA, FHA, or HUD. And you can also write to your servicer, and you would write what's called a request for information, or QWR. You send a letter to your servicer at the address that states either on the internet or on your last bill, and ask them, is your loan government backed? And that is one of the ways that you can find out whether or not it is. So if you have a government backed loan, what are your rights right now? Well, there are two groups of people that we're going to talk about. If you are a person that has already asked for CARES Act forbearance, we'll talk about you in a second. If you're a person who is behind or about to be behind on your mortgage loan, you have the right through June 30th to ask for a forbearance. And during that forbearance time, they cannot charge you additional late fees. They cannot begin a foreclosure, and they can only charge you interest in the amount they would have if you were paying. So you're not going to pay anything additional on the loan. That can last from anywhere between 12 and up to 18 months, depending on when you sign up for it and which program that you're under. If you are a homeowner that, if you have not done so already, getting a forbearance is required. You are allowed to go to your servicer and say, I want the forbearance, and and they have to give you one for up to 180 days, and then at least a second one for up to another 180 days. And it's completely under your discretion. It should be a fairly simple process. This next thing is, if you have a forbearance and it's coming to an end, as the delegate was talking about, what do you do? Well, again, we're going to have two groups of people. The first group of people are people that were less than 1 month or 2 months in some cases behind on their loan on March 1st, 2020. So let's say you're an individual that was making your payments and COVID has just prevented you from doing that. But now it's coming to an end and you're able to make those payments again. You're able to get back up on the horse and start making your pre-crisis payments. This should be a very simple process. And I say that, it's a mortgage foreclosure, so it's never simple, but they should just provide you a program that allows you to either put the money on the back end and extend your loan, or make it a lump sum payment that's on the back end of the loan, that it does not accrue interest during the time that it takes to pay it off. You should not pay any lump sum amount of money if you were one of these borrowers. If a servicer tells you that, they're doing it wrong, and you should write them a notice of error letter, which says you are trying to charge me a lump sum payment in violation of the law, and they should not do that. You should also talk to a professional if you're having these issues. Now, let's say you're a person who was behind on March 1st, 2020. Those individuals are a more difficult spot. There are programs through the government agencies such as a FlexMod, or a mod similar to that, where you're going to have to apply for a modification very similar to what you would have done typically. And you'll have to put in your, what you're making, what your debts are, whether you can afford the property. And there are waterfalls or other calculations that need to be made. Servicers often screw these up. And so you need, again, to speak to someone such as Beth or Strategic Housing Solutions that is able to run the guidelines and figure out whether you should qualify for a loan or modification, and or if you are close to qualifying for a loan modification. There are instances that we've seen where if you find out early that you're maybe a few $100s a month short or income short whenever this occurs, you can get a renter, or you can add a spouse who's not on the note to the modification. There are a lot of things that you can do if you know exactly how far you are away from that. And when you have a government-based loan, it's much easier to determine whether or not you're close. So again, find someone early, talk to them. You are not entitled to a loan modification if you are in this second group. That's the long and the short of it. You need to apply. There are many times that you might be in a mortgage that you just don't qualify for, or the trust might not allow for modifications. And you need to know that up front before you waste a lot of time. Now then the question becomes, what do you do if you have a non-GSE mortgage, or you don't think you're going to qualify for a loan modification? What you need to do first is figure out what your realistic goals are. I sort of break people up and clients up into three groups: people that should qualify for a loan modification, people that might qualify for a loan modification, and people that aren't going to qualify for a loan modification and are probably going to have to give up the property. Knowing which one of those groups you fall into is really going to guide the steps that you take going forward. What you don't want to do is be an individual who is not going to qualify for a loan modification and spend years fighting the foreclosure in court and incurring fees, attorney's fees on your side, and other things that's going to eat into the equity of your property whenever you weren't going to qualify anyways. If you're an individual that's close, or you're an individual that you might say, hey, look, I just want to stay in my house through the end of the school year so my kid can graduate with his friends, or we want to downsize, and so we want to get out of here, and we just want to be able to do this in a reasonable manner. If we know that, or if you know that, you can work out deals that will benefit you going forward, rather than being stuck in limbo. And so it's very, very important to talk to either a nonprofit or an attorney who's knowledgeable about this subject matter, and figure out exactly where you stand and come up with a plan of action that will help you do that. As I said at the beginning, there are no magic bullets here. There are no easy wins, especially given the lobby on the other side and the way that judges view homeowners. I've been practicing here for a decade, and in any other case, if the stuff that goes on in foreclosures went on in those cases, judges would lose their minds, attorneys would be disbarred, and sanctions would be flowing freely. But when it comes to foreclosures, judges don't seem to care. They allow the mortgage companies to put in documents that aren't legitimate or haven't been proven to be legitimate. They deny discovery when they shouldn't. They put the onus on the homeowner to prevent the foreclosure whenever the onus should be on the bank in order to bring it. And so you just have to be realistic about what you can accomplish. An attorney is going to want to see a few documents. There's a promissory note, your deed of trust, your last loan statement. If applicable, if you have any letters or correspondence from the servicer about your loss mitigation options. And then if you've used RFIs or NOEs beforehand to ask questions or have them answered, make sure to have those documents provided the attorney, so the attorney can look at them and see what your individual situation is and how the best way to handle it. I wanted to go back, and I had seen a question about dual tracking from the earlier session, and I wanted to make sure that gets answered. Dual tracking is whenever a loan servicer at the same time that they are they have received a full completed loss mitigation application. So you fill out your application, you send in all your documentation, the servicer says, we have the full application and we're now going to review it. Well, if it is your first application with that servicer or your first application with that servicer since you have fallen into default, depending on the timing of the application, they either can't refer the case to foreclosure, or if it's already been referred, but you're more than 37 days prior to a foreclosure sale. And many times in Maryland, there just won't even be a foreclosure sale set. You can prevent the foreclosure sale from occurring until you have been reviewed for loss mitigation. And they have to deny you properly. They have to send you a letter that says you're being denied because, and provide the actual reasons. And lots of times we'll see denials, especially from Wells Fargo, that say you did not qualify for the program and not tell you why. And one of the reasons it's important to know why you were qualified is that they make a lot of mistakes. And when they make mistakes, if you know what that mistake is, we've been able to fix those mistakes and help homeowners out. And so again, it's very important. And there's also case law that says if you haven't been properly denied, then the dual tracking protections can continue. So again, dual tracking shortly is if you have a completed loss mitigation application in and it's more than 37 days before the sale, they can't sell your property. I think that is everything that I have. I'll open up to questions if I have any time left, but if not, I will yield back to the floor.
Well, thank you so much. That was absolutely very informative. And geez, I mean, that was really a heavy lift for the homeowner because of judges and the way that the courts are ruling. But I'd like to ask Sheila Durant, Attorney Durant, what are the kinds of documents do you find are important to you? I know that Peter just named some, but what are the kinds of documents that you find are really necessary that you found? Uh-oh, unmute yourself.
Can you hear me now?
I can.
Okay, great. Peter and Beth were articulate about telling you exactly what you need and what you're going to be exposed to when the foreclosure happens. In terms of documentation, it's critical that a homeowner keep the correspondence between themselves. They seem to think that the servicer is a friend after a while. Oh, they know me. And they don't seem to want to think that keeping the records is important. It becomes critical in terms of demonstrating activity at some later point. So the correspondence that a homeowner has with the servicer becomes critical. I don't just save it. And that is emails and text and letters. Maybe in some instances, they've made extra payments. They need to keep a copy of their checks or their bank statement, something that they can verify later on, because if they get a history in this and these payments are not being reflected, then they've got something to say, yes, they were, this was cashed at that point. So if they can facilitate the process of discovery for the attorney, I think they'll be well along the process of protecting themselves, because everything that Beth said, everything that Silva said is right. I mean, it's just an unfair process. You've never seen anything like this before. It's shocking. It's shocking just how slanted it is away from the homeowner. And so if you go into it thinking it's the normal process, then you'd be foolish. So that documentation becomes critical.
Yes, we found that out in some of the things that we've seen in strategic housing solutions, where people just come in and say, help me, but they've got absolutely nothing beyond their case number that can help out, with the situation. So I've got to underscore that. And, and as I'm listening to you, I sort of heard Beth mention about the Black farmers and what happened with the Black farmers, Thomas Ruffin. Can you drill down on that for a little bit for us? Because I know that you had something to do with Black farmers. Share with us your information and whether or not you felt that was a real land grab that happened with the Black farmers.
with the black farmers, there's some similarity with what we're describing here. And however, the wrongdoing was largely perpetrated by the US Department of Agriculture, as well as by the State Department of Agriculture, and sometimes by the County Department of Agriculture. What would happen would be county, state, and on occasion, federal administrators would cheat black farmers who obtained either loans or were seeking grants, and they were discriminated against. So if they sought a loan, then the similarly situated white farmer might get the loan, but the black farmers wouldn't get it. And the loans for farming, which is a cash flow business, would be essential for the ongoing operation of the business. In that vein, this would work out when you looked at the pattern to be a deliberate effort to ruin black farmers in a county, in a state, or in a region, and thereby force far more black farmers out of farming and to lose their land than was typically the case in that industry. So because of this tendency, black farmers went to court and filed a lawsuit in federal district court. And after a while, during the Clinton administration, the clamor on the part of the black farmers became so loud, that is within their field of endeavors, that Newt Gingrich, the Speaker of the House at the time, and Clinton, the President of the United States at the time, took hold of that clamor and agreed, the head of the Republican Party in the Congress and the President of the United States leading the Democratic Party, that relief would be provided. And what had happened was under the Reagan administration, and then following up under the George H.W. Bush administration, but primarily under the Reagan administration, the US Department of Agriculture would receive complaints from black farmers alleging racial discrimination with the administration of home loan, federally funded or subsidized home loan programs, and also federally funded grant programs for farmers. And what the Reagan administration would do would be to destroy the complaints, throw them in the trash can, put them in the file and not attend to them. And when the Clinton administration came in, the Black Secretary of Agriculture revealed that this cheating was going on in the Reagan administration and to some degree in the George H.W. Bush administration. And that supported the claims of the black farmers and led to Gingrich and Clinton coming to this agreement. However, what would happen afterwards is something along the lines of what you have been warning people about. Don't deal with this casually. So the black farmers, again, dealing with a cash flow business and oftentimes either not having the capital to properly litigate these issues or saving their capital and rather than investing it into fighting against these issues, would deal with these problems without lawyers. Or if they had lawyers, they deal with the problem with lawyers who are incompetent. And as a result, even after Gingrich and Clinton waived the statute of limitations with new federal legislation and allowed these claims to go forward so that there could be relief, many black farmers didn't get the relief. And on top of the US Department of Agriculture, the State Department of Agriculture and the county operations continued to cheat in a racially discriminatory fashion against black farmers. So actually there was not one relief bill passed by Congress, that under Clinton and Gingrich, but then George W. Bush began the process of working towards resolving the problem again. And then when Obama became president, the bill came through again and new relief program came through. But even with that, all the black farmers who needed relief didn't get it. And moreover, this gets back to your question, Liz. There was a loan guarantee program wherein after there was a consent decree by the Department of Agriculture admitting racist bigotry in the administration of this program, and that many black farmers were not afforded guaranteed loans that would have protected them from insolvency, bankruptcy, or huge losses in their farming operations, they still cheated these black farmers in a racially discriminatory fashion. And so what has happened is that over the last few weeks, Senator Warnock, the new senator out of Georgia, Senator Scott, the Republican senator out of South Carolina, and Senator Cory Booker, the senator out of New Jersey, the 3 Black senators in the US Senate, have come together and provided leadership to push through the Senate Farming Committee a new bill that the Congress expects the House of Representatives to pass, but a new bill that provides relief and waives the loss of property because of this racially discriminatory application of the federal loan program for farmers. So that's basically it. There's similarities, it's not the same. And largely in what you're talking about, the cheat, whether it's racist or just opportunists, is coming from the big banks and small banks. In this, the banks are playing a role, but it's really the federal government, the state government, the county governments pushing it through white racists and their support network in the state governments.
Wow. That's a lot to digest. Thanks a lot so much for that. And you know, the similarities, like you say, are there, but it ends up in a land grab that our people lose so much with from land. And you know what, I'm wondering, Attorney Abdullah, just what the biggest problem is in defending against these foreclosures.
Well, there unfortunately is not one simple problem. As Peter and Beth have both said, timing, being realistic, and understanding that Maryland, unlike the District of Columbia, and I'm not certain because I don't practice in Virginia, what it's like, foreclosures in Maryland are what are called non-judicial. And that's a very misunderstood concept. In the District of Columbia, when you're in foreclosure, you can request, it doesn't happen necessarily automatically, but you can request a judicial foreclosure, and so that the burden of proof is on the lender or on the debt collector, the moving party, to go in and demonstrate that the foreclosure has met the legal standard. That is, they have the note, or they can explain why the note has not been presented, and that they have complied with all the requirements. And along the way, you can challenge that, and the court has to make a decision. But when the order to docket is filed in the state of Maryland, you're not going to get a court hearing unless you request one within the very limited time limits that the other panelists have referred to. So you can go through the entire process of foreclosure in the state of Maryland, never see the inside of a courtroom. What the court does, it reviews certain documents in a somewhat cursory manner to make sure that the reconciliation, certain things are done correctly. But if you, even when that occurs, you must comply with the very limited time periods if you want to challenge whether or not after the sale that the sale was handled properly, or that the accounting of the proceeds of the sale were handled properly, that the sale was properly noticed. These things here will not be in court. Courts will not review them unless you file something timely, or time limits are waived, which is almost impossible. So within the state of Maryland, it would be a great benefit if someone would pass a bill to require foreclosures in Maryland to require judicial involvement. Would they do that? Probably not. Why? Because that would bring hundreds of thousands of cases into the court. So we have to understand this. Foreclosure in Maryland is a private matter. It's not a public matter, unlike the District of Columbia. Very, very huge difference. So but I want to kind of move back on a couple other things I wanted to talk about before we
By all
got
means.
further. Now, we talked about some definitions. I want to add another definition, and that is the mortgage. I don't recall hearing it, but there's also the mortgage broker. And this subprime market that really took off in 2006 and 7 and 8, one of the things that really drove that market greatly was the mortgage broker. These were people who got paid $5,000, $10,000, $500 just to take someone who had a perfectly good mortgage and say, we can get you a better deal. Of course, they were lying. Why? Because if once you sign the mortgage, the subprime mortgage, they got paid right away and they moved on to the next one. And so there was a sub market dynamism of the mortgage broker that were coming in. It's almost as if someone was paid to break up a marriage. Their job was to do cold calls to poor and ignorant homeowners and sell them new mortgages. And some of these mortgages, they say, well, there's no paper. The first 5 years will be you pay interest only. So you're looking at a mortgage that's a very good mortgage, and they come to you and say, "Oh, well, yeah, you're paying $1,000. We'll get your payments down to $50 a month, interest only." But when the balloon came, and when the crash came, you were left in the dire straits. So that's one party. And the other party I want to talk about is that there was a question about how can some persons who are debt collectors pursue you in foreclosure. Well, if they're a holder of that note in due course, they stand in the same shoe as the original lender. Of course, all of your defenses that you would raise against the original lender can raise. But just because someone is a debt collector, don't believe, you heard on the internet, that they have no rights. Don't believe that if you incorporate yourself, that you're insulated from foreclosure. And so some of these remedies that you may have gotten because you spent the night at the Holiday Inn don't work in the real world. See, there was something else I wanted to talk about, and that is
Take your time.
Okay, dual tracking. Something very important about dual tracking. It's not a Maryland law. And it's, in fact, actually, it's not even a law. It's a federal regulation. And the Maryland courts, including the Court of Appeals, they don't really respect it. It's very difficult to get a circuit court judge to really understand it and rely on it, because they are mesmerized by these large firms that admittedly, typically, oftentimes, and I'm sure Peter's an exception, but many attorneys simply are not versed on foreclosure law, and
Absolutely.
that can't match wits in the courtroom, because the courts have a bias. They assign these foreclosures to one or two judges, and they're overwhelmed with these things, and that they really are not sensitive to the fact that it is the homeowners that their rights that they need to protect. And so I find that dual tracking, the best way to use that is in your negotiation with the attorneys, and to point it out, yes, you have a dual tracking problem and you need to do something about this sale, or we're going to deal with this. So I found it's most effective to use dual tracking, the dual tracking problem, which happens often at the negotiation stage, to try to stop the sale and to get another bite at the apple by the consumer. Now, let's see if there was anything else. Well, I mean, those are essentially the things. The problems I find is homeowners oftentimes have been told by entities, non-legal entities, that if they take certain steps by, I guess, incorporating themselves, that they can't be, and that they become some kind of entity that the courts can't touch. And so we have to be realistic, as Peter said, and you've got to understand that purchasing a home is like any other contract. If you cannot afford that home, you need to look at an alternative of how you can either forestall the foreclosure long enough so that what you want to do is accomplished and come out gracefully, or to try to get into some type of program where you can get a short sale or bring in other family members that can assist you. So I find that if the homeowner comes in early and the homeowner is really focused on following the advice of competent counsel, they have the best shot of coming out of this with their home still in their possession.
Thank you so much. That was riveting. Thanks so much for sharing with us. And but God, I mean, with all of this that homeowners have coming at them, Kelly Baker, are you there? Attorney Kelly Baker? I guess she's not there.
Okay, no, I'm here. I was trying to unmute. I think I got it.
Okay, well, you're looking glamorous. Yes, thank you so much. It's good to see you. How long does this take? How long does this take for people to go through this process?
Well, I've been doing this since 2009, and it can be a very long process. I mean, I've had some cases take up to 3 years back in the first wave of foreclosures. And now with COVID, I'm dealing with cases that were prior to COVID, and now they're starting to get back on the calendar. Unfortunately, just had a property go to sale, even though we have an appeal pending. And I would like to thank Attorney Abdullah for mentioning dual tracking. I just want to explain it a little bit more. I want the people of Maryland to know, and my goal is to get the word out through the NAACP and Strategic Housing Solutions nonprofit. I want the word to get out that the servicer is not your friend. And I mean, and it's hard for people to understand, especially growing up. It used to be a community bank. You used to know your banker and they cared about you. And so it's really confusing to understand why these people on the phone don't have your best interest in mind. It's really confusing. And as attorneys and advocates, because we've seen hundreds, if not thousands of these, you hear the same story over and over again. I thought I was working something out with my bank, and they're not even a bank, but we're not going to even touch on the technicalities. But, I thought I was working something out. And next thing I know, I get an auction date and I call and they said, don't worry about it. We're still going to work something out. And so people don't realize that their house is being sold from right up under them. And once the house is sold in Maryland, you lose so many rights. You lose so many rights that you could potentially have brought up and defended prior to an auction sale. And so it's a big bait and switch. And I think at a minimum, all of the unsuspecting people that are in this forbearance that's going to come to an end need to know that servicers are snakes. Period. I don't even want to sugarcoat it. You got to play from the defensive. And that's my biggest concern for our community in the state of Maryland, Black people in Prince George's County and across the state in particular, who were more prone to have the subprime loans, but it's everywhere. And there's so many more people that are facing a hardship now, restaurant owners, hotel owners and managers and performing venues, that it's not even a race or class issue anymore. And so I think we all need to look out, at the state level. And I'm really impressed with the terms of that bill. Thank you, Beth, and all of our local House members and delegates for working on that. But we got to get that thing off the ground, because I'm very concerned for the state of Maryland. And I'm very concerned about the home ownership rates and what's going to happen to our people with permanent lifelong tenants, or I don't know what the goal is, but it's a land grab for sure.
Plain and simple. Absolutely plain and simple. And but let me ask you something, Beth. Are you there? Beth? You got to unmute yourself.
I'm here.
Okay, so what can people hope to accomplish in mediations? I mean, with with these land grabbers just waiting, salivating and wringing their hands. They're just so happy that this is about to happen. What can we accomplish in mediations in that nothing that you do in mediations can be used in a courtroom? How can mediations help us?
Well, we have to push the circuit court judges that if the bank didn't supply the documents that are required under law, under Maryland law, that we want a hearing to ask for the foreclosure action to be dismissed. Now, I've only been involved in one case where a foreclosure action was dismissed based on mediation, and that's where the servicer didn't show up. So it's not an easy task, but the law is there. But mediation gives you the opportunity, I'll call it mini discovery, where you can find out information. You can ask, well, what is the servicer's or the investor's requirement for loan modification? Will they extend the term of the loan? Do they allow principal forgiveness? Do they allow principal forbearance? So those are the types of questions that you actually get somebody from the servicer on the phone, and you can ask those questions. So you can use it at that, which is why I recommend that you go to mediation with an advocate, somebody that has done these mediations before and knows the questions to ask. So I'll leave it there. I know there's a lot of questions that are out there that people are trying to get answered.
Yeah, Liz, I was about to say, maybe we should jump over to answering some of these questions from the chat. I could read them off to you, and then maybe you could, you know our panel really well. Maybe you can call on someone from the panel from there. Would that be all right?
Very good. Read them off, please.
Okay, we've got so many, but let me try and grab a good one in here. One question that has been asked is, can someone please define the different players in a mortgage? In other words, what is the difference between a bank, a lender, a secured party, the mortgager, and the servicer?
I can answer that. So a lot of times the bank and the mortgage company are the same entity. And so that's who you go to talk to, a representative from the bank or the mortgage company, to obtain your loan. The servicer is think of it as like the middleman. The servicer represents the investor of the loan and collects the mortgage payments. And if you escrow, which means that you have the mortgage company pay your taxes and insurance, the servicer pays those. So the servicer is the go-between, because you will never have a conversation with the secured party or the owner or investor. So secured party, owner, investor, they're all the same terms. They're just, that means the entity that owns your loan. It could be Fannie Mae, it could be Freddie Mac. It could be this long name, Deutsche Bank, for the trustees of the Securitized Trust 2006 pass-through certificate holders. So that could be the secured party with that. But typically, it's changed a little bit after the mortgage meltdown, the Great Recession, is that banks originate the loans, they obtain the mortgage, but they don't hold on to the mortgage, they sell it. So a lot of times they're sold to Fannie Mae, Freddie Mac. They're also sometimes have insurance from VA or FHA, and so then the secured party has to comply with the with FHA or VA restrictions and guidelines as to servicing the loan. There was a law that was passed, it was May 2009, that stated when your loan is sold, the borrower has to be notified by the new owner of the loan within 30 days. That doesn't happen a lot of time, and that can result in what's called a truth in lending violation, that you can actually go to court and sue the investor of the loan if they didn't notify you of that. But if your loan is sold, you are supposed to be notified who the owner of the loan is, and if the servicing change, you're required under RESPA to be notified of who the new servicer of your loan is. I hope I answered that question.
Well, speaking,
It
I was just wondering about, speaking of RESPA, but I guess we've got to get to these questions because this has been so riveting. Go ahead, Hamza. What's the next one that you see?
Another one we have in here is from Jacqueline Arundel, and Jacqueline is wondering, are there any examples in the United States where the laws work better in regards to fairness to individual homeowners?
Peter, you're on.
So in the District of Columbia, we actually changed the law recently. We are still a non-judicial foreclosure state, but what the district did was make it so onerous on lenders to foreclose non-judicially that they are all voluntarily choosing to use the judicial foreclosure. And I have found that it is much, much better to be in DC. I think, Beth, there's another state that we've talked about that you think has a better program right now. Who was that?
I think, well, New York has a good program because they stress mediation. So the problem with Maryland's mediation process is the administrative law judge is basically just there as a referee. They have no authority to really do anything. In New York and in some other states, the judge, the mediator, has the authority to say, in 30 days, I want all the parties to come back and I want the servicer to have reviewed these documents, and can say, and we'll put that type of binding requirement on all of the parties. And the good thing about this is rarely do those cases get to the court system. So they're able to resolve the issues, any of the issues, if it's going to result in a modification through mediation. If it's an issue of forgeries or other documents or unclean hands, that still has to go through the court system. But if it's mostly just to try to mediate for modification, that's done outside of the court system.
Thanks so much, Beth. Another question we have here is from Charles Chapman. Where can we get a summary of the House and Senate bill to help with the writing of our emails? I'll answer that real quickly, Charles. We'll be following up with you via email by tomorrow via Progressive Maryland, and we will have a summary as well as a list of emails for you to shoot messages out to. We're also going to ask folks, if you have Twitter, to go on Twitter and follow Progressive Maryland there. We will be tagging members of the House of Delegates and the Senate who serve on the relevant committees, so that you can also tweet at them and make sure they get the message that we expect them to take action for homeowners and not for the benefit of banking lobbyists who deposit thousands of dollars into their campaign accounts. So that being said, let's see if there are any other questions. Does anyone want to ask a question from the audience? Just go ahead and type it in right now.
Hamza, before you, this is Raul, before you go there, I wanted to make a really quick comment about the difference between the mortgage note and the deed of trust, because I know we had discussed that. The deed of trust, which not all systems use that, but the deed of trust is a document in which the lender, you actually issue a deed to the trustee that becomes active when the foreclosure has been granted, and it allows the trustee to issue a new deed to the new purchaser if the house is ever sold. So the note is actually the contract to say, I'm going to borrow this for that. The deed of trust is the mechanism by which your house is sold should the house if the notice is accelerated to a foreclosure. I don't know if everyone agrees with that analysis, but I just wanted to make it clear that the deed of trust is a vehicle for the selling of your home. Okay, I'm sorry about that.
No worries. Essentially, a deed of trust is a document through which a third party is authorized by the note holder, the person who owns the investor in your note, and the loan processor or the loan servicer rather, to sell your home. The idea is that the third party has a clean conscience and they're not involved in any way in stealing your home. And so they can prove for a fact to the court or to anyone else that you are behind on your mortgage, and therefore it makes sense to foreclose your right to redeem your property and your mortgage. That is a very interesting theory that we have in common law, especially in the US. It is not how it actually plays out, as many attorneys will point out here. Oftentimes, those who are assigned the deed of trust are in on the act of selling your home and getting a commission from your home being sold at a foreclosure sale. Therefore, take it with a grain of salt. You can't really trust that process, and no one is really sure why we still have it, except for the fact that it means more people can make money off of people struggling with their mortgages. That being said, there are several questions that have been asked in the meanwhile. Frida Shelton asked a question: what, if any, training exists for judges and attorneys to learn more about the securitized loans and foreclosures? I will answer it quickly, but I know that Elizabeth Johnson has a much better answer. The answer is actually not very much. For the most part here in Maryland, those who are appointed to become judges in our state are done so by special interests who have a vested interest in making sure that the judges reflect the most powerful law firms in our state. Even though we have the power of elections to keep judges from being too inside of an interest group. Several elected officials are working hard to get rid of that power of elections, and Progressive Maryland has been working hard to protect our right to elect judges, because here in Maryland, as I recall, only 18% of our judges look like the majority of the state. The vast majority of our judges do not look like the state, either as people of color, people of various income levels, or in fact, of the people who become judges. Very few of them are civil defense attorneys or attorneys with backgrounds in public defense, or attorneys who work at legal aid clinics. Rather, they oftentimes hail from powerful corporate firms or have interests in prosecutorial backgrounds. That's a huge challenge in terms of making a case to a judge, because a judge is going in oftentimes with a deliberate bias. And to that point, just to throw this in as well, Maryland jails more people of color than any other state in the union by dozens of percentage points. The next closest state, I believe, is Mississippi. They are well behind how many people of color they jail. Maryland jails as many as 85% or more of our inmates are people of color in a state where only about 51% of the population is not white. Raises a lot of questions about how we do things in this state. And I think we're all very familiar with how broken our criminal justice system is. The same is playing out in our civil justice system. That being said, I am sure we have other questions to go over. Actually, I'm not seeing any. If you are in Chapter 13, can the bank refuse to accept the payment from trustee? I'll leave that to the attorneys. Sheila, I believe you've dealt with this situation a few times, and so has Peter. If either one of you want to jump in right now, please go.
Sheila, can we hear from you on that question?
So what was the question you had to do with, what was the question again?
The question is, if you are in Chapter 13, can the bank refuse to accept payments from the trustee?
They can, but if they do, then the trustee steps in and has a right to disallow the claim, the outstanding pre-petition claim that was filed, and then that could wipe out that entire claim. Do you understand what I'm saying? So if you went into bankruptcy owing $75,000 to your mortgage company, and for whatever reason, the mortgage company decides it does not want to accept the payments that have been approved by the court, and the trustee continues to tender it, and the bank, and the mortgage company refuses to take, then the mortgage company can step in and get the court to disallow that entire claim and literally wipe it out.
Wow.
Thank you. Thank you so much. We're running out of time here. We wanted to close up around 8. We have so many great questions. I'm going to go ahead and say the following thing. We're going to be following up with everyone who's on this call tonight via email through Progressive Maryland, which collected everyone's emails. So you will be receiving something for sure. This will also be put online on YouTube as a recorded video for people to watch at their own leisure. And we're going to be following up with several smaller webinars dealing with different parts of the foreclosure process. Now, this is where I'm supposed to throw in some calls to action. I want to start with a call to action that is not directly a part of what we're doing. Rather, it's about the important work of Progressive Maryland. And I wasn't even going to talk about this, but this is so important tonight. In Maryland, when we have circuit court judges appointed, they have to then go through a retention election. The people decide if they want to keep them, and everyday attorneys can run against those judges to replace them. In Maryland, foreclosure proceedings happen at the circuit court level. Right now in Annapolis, special interests are trying to strip, I repeat, strip the public of their right to elect judges from the public who are themselves attorneys. The arguments being made are a bit odd, including the fact that maybe those attorneys aren't vetted enough to be actually judges. That is not a very effective argument. It's really a lot of special interest work behind the scenes. If you don't believe me, just look at how bad Maryland ranks in nearly every criminal justice and civil justice poll done by academics across America. We are in terrible shape. The judiciary is in terrible shape. Also, many of our Court of Appeals judges and Court of Special Appeals judges hold millions of dollars. I repeat, millions of dollars in real estate investments, which again raises the question about whether they're properly divested in order for them to rule these issues. And forgive me, my computer talks to me in French, so forget that in the background. This is incredibly important for why you have to be involved in Progressive Maryland and involved in next year's elections. Our state has gone from being one of the most prosperous and happiest places to be in the country, being ranked as one of the saddest places to be in the country by a CBS poll just a few days ago. Just think about that. And at the same time, we're going through a national, I repeat, a national epidemic of homelessness because of foreclosures and evictions. For a very long time, my generation, the millennial generation, has played a backseat role in public policy and only whined and complained. I am actually the only millennial who's a part of our task force because I'm the only millennial with family who owns a home that I know of, actually, believe it or not. And so this is something we have to take seriously going forward. If we're serious about changing our future, we must be involved with the work of Progressive Maryland, the NAACP, and all of our partners here today. Now, our calls to action going forward is that we will be calling out the elected officials that we need to be in touch with via Twitter and email. You will be shared those contact points via email by Progressive Maryland over the next 24 to 36 hours, inshallah, God willing. And so with that, we need you to get your friends involved. We need you to get your families involved. Every single email you send out to an elected official will make a huge difference. Elected officials in Annapolis are very used to collecting $54,000 salaries and doing very little actual work until they get a bombardment of emails around session time when they have to pass dozens of bills to justify us paying them that extra salary for essentially 3 months of work. It's time that we make them earn their buck. They get a dedicated salary to pass these laws, not to do the special interest work of banks or anyone else. We are the people of Maryland. It's time we get them to respond to that. And so I'm going to end on that point. That's my call to action. I really want to thank all of our panelists for being here. I want to thank the hidden heroes of Josh Rasnick and Scott Weber, who made this all happen. They're the tech people. I might be South Asian and a millennial. I don't understand computers. God just made me that way. I want to thank Liz Johnson and Beth Jacobson for working to put together such an amazing panel. I want to thank our panelists. I'm going to forget all of your names, forgive me, but Peter Silva, Sheila Durant, Kathleen, everyone who's here with us tonight, Brother Raouf. It's been a wonderful time. We will be following up. We're going to be doing a lot of great work together, not just this year. Remember, next year's an election year. Politicians might grovel at the feet of their donors, but donors can't save them from the wrath of voters. And we will be turning out across the state through Progressive Maryland and all of our allies to hold in account any politician who makes, as we say in Urdu, puja to the banking lobby, who worships the false idol of the banking lobby. Thank you so much. Take care.
Good night.
Good night.